Hey, y'all. They haven't entered the courtroom yet, but I know several of you are probably watching the verdict on Trump, and he's been found guilty. Trump, guilty. So he's, I'm watching a feed right now. On every single count, he's been found guilty. As we wait for the sentencing phase of the Chad Daybell trial to begin, where we will figure out whether whether he will face the death penalty. Now, I think I might start another poll about the death penalty because now we know that he's been declared guilty, found guilty on all counts. And I'm right now talking about Chad Daybell. Chad Daybell has been found guilty on all counts. So it might be a little easier for people to determine whether they think he will get death penalty or not. I'm gonna say they might. I mean, this jury came back so fast. They came back so fast with a verdict. That's right. Trump guilty on all 34 counts. He's guilty. Chad Daybell guilty. Trump guilty. Chad may be happy that Trump is taking away some of his, hey, Caroline, some of his social media heat. He's like, oh, thank goodness. People are tuning into the Trump trial, not mine. Just kidding. But so we're just waiting for them to come in. They should be coming in any moment. Yeah, he kind of does, Teacup. That's true. Apparently, Trump fell asleep several times during the trial, like literally, like mouth agape, back in his chair. And there were some times when I was looking at Pryor and going, is he doing the same thing? Yep, Trump is guilty. I was looking at Pryor during the trial sometimes, and I'd look at him, and his face was in that a little bit of that, kind of slack jawed look on his face. And he looked like he was about to fall asleep. So let me see if there's any updates from inside the courtroom in Idaho. I hear them coming in. I hear them coming in. So, but they haven't turned on the camera. Yeah, the unfortunate thing about the Trump trial is you can't see anything. You have to wait for the reporters in the courtroom to say stuff to people outside, and then it's an echo effect. So, they haven't really given us a lot of insight into how this is gonna go, but for sure, there will be victim impact. And I saw a tweet from Annie Cushing. She is Tylee Ryan's aunt, and she said she believes she's gonna be giving her victim impact statement this afternoon.
All right, once the jurors are ready to be brought in, they can enter the courtroom, please. Yes, Your Honor.
Let's get a little closer up on Chad one moment. Like he is probably, I would say, among the most emotionless defendants I've ever seen. Now, when they were about to read the verdict, what I noticed is that, whereas he usually sits there, hello, Pink Rose, um, whereas he usually sits there with, like, his hands on the table and his hands clasped while they were getting ready to read the verdict, he would like his hands were just kind of black onto his lap, and he sat there like he was waiting for a beating, right? But still, you didn't see a lot of emotion. And it kind of harkens back to what his daughter said on the stand, which was that it was really scary for her to see him out of control and losing it when her mother died. And obviously, hey, hello, lurker, Grandma Cece. um, so we're now on the sentencing phase to determine whether Chad will get the death penalty. One wrinkle in all of this is that John Pryor, Chad's attorney, who he's been loyal with all this time, is not death penalty qualified. And part of the whole one of the reasons this trial took so long to take place was because the state was needed to get death penalty qualified people. And the idea was for Chad to get a death penalty qualified lawyer, but he was never able to find one. He wanted to stick with John Pryor. That's right, Chopper. Right. Now, Chad looks a little bit like he has a tiny bit of a grin on his face. I'm just really checking him out, in the aftermath of his finding out of us being able to call Chad a murderer. Chad, you and your wife are murderers. Not only that, you're a dumb murderer. You're dumb. Your little brain drove your ideas.
Here's our President counter for you, Your Honor. Thank you. Please be seated. All right. Good afternoon, everyone. We are back on the record on case CR 2221-1623, State of Idaho versus Chad Guy Daybell. The court notes that earlier this afternoon, the jury returned a verdict of guilty on several counts that are subject to this capital sentencing phase, including in the verdict form counts 1, count 2, count 3, count 4, count 5, and count 6 of the amended indictment. The court at this time then is going to commence with the capital
That's
sentencing
true, Claus.
phase. I'll note that in this case, the jurors have returned, including the juror alternates that are here as well, and the 12 jurors who returned the verdict under Idaho Code 192515, subsection 5B. The court is using the same jury to conduct this phase of sentencing also. And that statute reads that if the defendant's guilt was determined by a jury verdict, the same jury shall hear the special sentencing proceeding. So we are in that special sentencing proceeding. As I mentioned, the jurors are here and present. And ladies and gentlemen of the jury, thank you for continuing your jury service. You've again been seated for your continued service in this case. And that's the matter we're taking up at this time. To give you an idea of just the schedule, the court has some preliminary instructions that are going to be read to you this afternoon. We're going to commence then with further evidence on the sentencing phase starting tomorrow morning after I read these preliminary instructions. And the court's proposal on our typical scheduled plan would be to start at 8:30. Is the state going to be ready to proceed at 8:30 with any impact statements that may be offered?
Yes, Your Honor.
All right, that's how we'll run the scheduling at this point then, and I'll inquire as to the jurors going forward. Also, the scheduling we'll have during this phase of the proceedings. They don't need to be limited to the timeframes we've had throughout the trial, including, depending on how long this takes, weekends. So I am essentially leaving up to the jurors their proposed schedule within reason of when we'll work through this proceeding. So the court is going to read some preliminary instructions then to the jurors. And again, you'll receive additional jurors when you retire to deliberate on this part of the case. But for now, the court will just read these and those will be included with you later. So in this case, the defendant in this case has been convicted now of the crimes of first-degree murder and conspiracy to commit first-degree murder. We will now have a sentencing phase of the trial regarding those offenses. Additional evidence may be presented during the sentencing phase. You should also consider the evidence presented during the trial. Before the death penalty can be considered, the state must prove at least one statutory aggravating circumstance beyond a reasonable doubt. If you unanimously decide that the state has so proven one or more statutory aggravating circumstances, then you must decide whether the imposition of the death penalty would be unjust by weighing all mitigating circumstances against each proven statutory aggravating circumstance. At a separate proceeding, the court will sentence the defendant for other offenses of which you have found the defendant guilty. Instruction number 2. Your duties are to determine the facts, to apply the law set forth in my instruction to those facts, and in this way to decide the case. In so doing, you must follow my instructions regardless of your own opinion of what the law is or should be, or what either side may state the law to be. You must consider them as a whole, not picking out one and disregarding others. The order in which the instructions are given has no significance as to their relative importance. The law requires that your decision be made solely upon the evidence before you. Faithful performance by you of these duties is vital to the administration of justice. In determining the facts, you may consider only the evidence admitted during this trial and during the sentencing phase. The production of evidence in court is governed by rules of law. At times during the sentencing phase, an objection may be made to questions asked a witness or to a witness's answer or to an exhibit. This simply means I'm being asked to decide a particular rule of law. Arguments on the admissibility of evidence are designed to aid the court and not to be considered by you nor affect your deliberations. If I sustain an objection to a question or to an exhibit, the witness may not answer the question or the exhibit may not be considered. Do not attempt to guess what the answer might have been or what the exhibit might have shown. Similarly, if I tell you not to consider a particular statement or exhibit, you should put it out of your mind and not refer to it or rely on it in your later deliberations. During the sentencing phase, I may have to talk with the parties about the rules of law, which should apply in the case. Sometimes that will occur at the bench. Other times you may be excused from the courtroom so that we can discuss those matters. You are not to speculate about any such discussions. They are necessary from time to time and help the sentencing phase run more smoothly. Some of you have probably heard the terms circumstantial evidence, direct evidence, and hearsay evidence. Do not be concerned with those terms. You are to consider all the evidence admitted during the trial and during the sentencing phase. However, the law does not require you to believe all the evidence. As the sole judges of the facts, you must determine what evidence you believe and what weight you attach to it. If any evidence is admitted for a limited purpose, you are not to consider it for any other purpose. There is no magical formula by which one may evaluate testimony. You bring with you to this courtroom all the experience and background of your lives. In your everyday affairs, you determine for yourselves whom you believe, what you believe, and how much weight you attach to what you are told. The same considerations that you use in your everyday dealings in making these decisions are the considerations which you should apply in your deliberations. In deciding what you believe, do not make your decision simply because more witnesses may have testified one way than the other. Your role is to think about the testimony of each witness you hear and decide how much you believe of what the witness had to say. A witness who has special knowledge in a particular matter may give an opinion on that matter. In determining the weight to give such opinion, you should consider the qualifications and credibility of the witnesses and the reasons given for the opinion. You are not bound by such opinion. Give it the weight, if any, to which you deem it entitled. Instruction number 3. It is presumed that no statutory aggravating circumstance exists in this case. This presumption remains throughout the sentencing phase and during your deliberations. The state has the burden of proving the existence of a statutory aggravating circumstance, and that burden remains on the state throughout the sentencing phase. The defendant is not required to prove the absence of any aggravating circumstance, nor is the defendant required to produce any evidence at all. The state must prove the existence of a statutory aggravating circumstance beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. That in this time then concludes the initial preliminary instructions for the sentencing phase. And the court is going to be in recess then until 8:30 in the morning, when we'll commence with evidence on that phase of the trial. Before we break for the day, does the state have anything further?
No, Your Honor. Thank you.
Anything further from the defense?
Nothing, Your Honor. Thank you.
All right, thank you. I'll note then the jurors will remain sequestered during these proceedings, and we'll begin again tomorrow at 8:30. Thank you again for your continued service, and that will conclude our matter for today. Thank you.
All right.
Okay, that was quick. So they're going to start the actual witnesses tomorrow. So he was just reading the jury instructions. Neat Noodle, I do not know for sure. I don't know if his age and disability are aggravating circumstances. They should be, obviously. I don't know for sure, though, if that was in the indictment. I really don't know. So we start again tomorrow on the sentencing phase of this trial, where we will hear witnesses. I had originally thought that they were going to start some victim impact statements today, because Annie Cushing, hey Molly Lollipops, she had tweeted that she was going to be there, and she thought she might be giving her statement this afternoon, but apparently not. They're going to start tomorrow. The judge said, since the jury is sequestered, they may go into the weekend. So if they go into the weekend, I'll go into the weekend as well if they're streaming. So stay tuned for my notifications. And just so you know, you do unfortunately have to probably look proactively for my channel. I have most likely been shadow banned. I'm not a super special person. I'm just an ex-Google employee who says mean things about what they're doing to the world. And so they just said, boop, we're going to hit the off button. So you do have to kind of look for me, and I'm glad that you do. I'm pretty sure that most of you who are here had to look for me, or you were here recently, and that's how you were notified. But I really appreciate, oh, good. I'm glad I showed up for you, Crystal. I think I show up for people who were recently visiting my channel. But I know, Crystal, you said before that you had to actively look for me before. So that might be why, is that you're actively looking for me. And then, yeah, I know, Molly, that's what happened. And Sparkles, you probably notified because you're here, and you've been here practically every day. But my subscribers don't get notified. Like, if just because they're subscribers, they don't get notified. The people who, I'm glad you do, Molly Lollipops. The people who do what was I going to say? The people who watch similar channels like mine, and probably would like the content that I'm making, they probably don't get notified. They probably don't get notified. So, I have no way of knowing exactly how my my channel is silenced. Yeah, Alex is always awesome that way. I appreciate that. That's probably why Walker Way Renee. I think my Rocket Man algorithm is strong, unfortunately. Oh, I'm glad she did, Grandma Cece. I appreciate that. So I do appreciate when people let you know I'm here. Pulling people in. I'm not sure what you mean by that, Chopper. Hey, look, just so you know what my stance is on this, there's not much I can do to override what they do. Okay. There's just really not much I can do to override what they do. I could maybe do it temporarily, but I will always be an ex-Google employee who says mean things about them until they stop doing what they do. That's always going to be the case. As long as I'm speaking publicly about technology, I'm going to talk about how these platforms are fucking with future generations. That's just always going to be the case. So I'm not going to change that. So I just need to change where I say these things. I don't need the YouTube platform to say these things. There's millions of other platforms, ways that I could get this information out. Don't forget, I was part of a group that created billions of impressions of news about all of this and then was in a documentary about it. There's many other ways to get this message out. I just happen to be using YouTube at this point. And true crime is a very deep interest of mine. And so I always put it in the context of true crime, especially because my channels would have been shadow banned a lot sooner if I had just made channels that said, YouTube sucks. You know what I'm saying? So anyway, all right. Thank you, everyone. I really appreciate you all. And I will see you tomorrow for the beginning of the impact statements in the sentencing phase. And thank you, jury, for bringing justice to the people that matter most in this situation. Tylee and JJ, it makes me want to cry to see their little faces. It really does. And Tammy Daybell. They didn't deserve it. They didn't deserve it. And that's why we're here. Justice is served. And now let's find out what he gets. All right. Thank you all for being here. And I will see you soon. Bye.